Abusua ye to yen ka bi nhyiam na breaking news bi bae ne nyinaa ye Mami Toko no ne suspension e bae no na emmara no esesen according to Omampanyin ogina article saying 146 eno ere or the suspended mami no be abedi nkomo for article 146 na ye ho ne say Commonwealth instructed the state the president to reinstate a year Mami Toko no with immediate effect. Na abusua ye ni nkomo na ye nhwe wo mo Commonwealth na nye se buro ni fitaa bi na ehye kire no otworo letter na abre Omampanyin se won reinstate eye Mami Toko no eye NPP bidding agenda na obehun se NPP for na nkasa no omo ye suma ntina Rollins ka say don't underestimate onipa NPP ni me underestimate ye na esi Yaba beye discover bi ehun say according to political hazard NDC political hazard o call omo handle obehun say Commonwealth Lawyers Association we na Commonwealth Lawyers Association we wo hwe din na ye wo Botswana Tango Ribadiri ono aye part of the lawyers and ye wo Cameroon oye Roland Abin ono so eka Commonwealth lawyer no so no and ye wo Gabon currently vacant and ye wo the Gambia Siliu Tal ono so ye part ana Ghana no so ye wo Justin Amanuvo na onim say Justin Amanuvo we oye MPP ni yes because Ghana Bar Association in connive with a Commonwealth Association now na just say nipa or share Commonwealth and Sasha as a friend Brabaron or Ghana ni free takrade busia na MRM say Joe Gatti woman Ghana Bar Association no or down on Joe Gatti ne yere a oye MPP ni tie busia story no na oko sa Justin Amanuvo good Justin Amanuvo we are make can answer me we MPP ni obe say bra and I say cratchy fat ben na o kase Justin Amanuvo no MPP ni made call 2020 election petition yes o 2020 election petition they call a court on Justin Amanuvo no and associate no no one say ne firm no na oye legal parent no and sana all Commonwealth one and this that's the Amanuvo and associate no and Akufo-Addo and Prempe and co to represent respondents. We 2020 election and Justin petition a year election petition Justin Amanuvo we then respondent and I say ojine muma a year MPP abusua enti ye di nkomo na there's a Justin Amanuvo into me read the story bi actual 2020 election petition and there was two law leading firms, Amanuvo, Justice Amanuvo and Associate, and Akufo-Addo and Prempe and Co. On Monday filed a notice of appearance at the Supreme Court. The move essentially informed the Supreme Court that the firms will be representing the respondent to the election 2020. And not just say Justin Amanuvo American SME or MPP bidding for a long time. No, and I made Chiromo share no, Anna current secretary, secretary to the Commonwealth, and Henley, Honorable Shelley Ayokobochi. Na Honorable Shelley Ayokobochi no, Memo Renfi say, na Akufo-Addo man appointment be. Na appointment no, or MPP ni, yes. Honorable Shelley Ayokobochi no, a minister, former minister of foreign affairs but they say or a Commonwealth General Secretary or a MPP ni see or no see a MPP ni a year Justin Amanuvo or a lawyer and the Secretary of Commonwealth and also a MPP ni former foreign minister Honorable Shelley Ayokobochi so into no kuna by a course na a year Shelley a year Joe Gattin's wife and a Ghana Bar Association into we kuna even which means a MPP body na just say emfa yes na just a crime be one person who defending my reinstating no according to article 147 article 146 esoka den eno ye be di ho nkomo o de enko more details from TV3 ene Dr. Ren Nembra
correspondent bringing us the. I want to spend the last few minutes of our program tonight on the news we had in the last hour and the response from the Attorney General just before we came on the air, because we know that the Bar Council of England and Wales and the Commonwealth Lawyers Association have demanded an immediate reinstatement of suspended Chief Justice Gertrude Torkornoo to office. In a joint statement on Thursday, August 14, 2025, they said the reinstatement should be done without delay. Now, I want to show you highlights from that statement real quick. Now, there it is. That statement's coming from the Bar Council of England and Wales and then the Commonwealth Lawyers Association. It says, suspension of Chief Justice is in clear breach of Ghana's constitution. Judges under Ghana's laws should only be subject to suspension or removal only for reasons of incapacity or stated misbehavior. And then decision of investigative committee, to permit petitioners to use witnesses instead of attending themselves to answer questions. That's not follow due process. And then the disciplinary proceedings should have been resolved in a timely manner. I know some of these things are very familiar for you, and if they are not, they very much resonate with what we've heard from the Chief Justice over time, how her family is not allowed in the hearing area, how she feels intimidated over and over again. She's taken a number of cases to court as a result of what she thinks is not a fair process for her removal. Now, and the demands from the UK Council or Bar Council is that the Chief Justice is reinstated immediately, afford her due and fair process in the investigation and determination of the disciplinary matters brought against her, provide clear and transparent rules of procedure to guide the disciplinary process, which must include the time frame within which the investigating committee must conclude the disciplinary process against the Chief Justice. So that's a summary of what we're hearing from the Bar Council of England and Wales and the Commonwealth Lawyers Association. Yeah, but I'll bring you some reactions from social media. I do want us to look at what the Attorney General is saying in response to this demand or these demands from the Bar Association or the Bar Council of England and Wales, and that statement came in the last few minutes just before we came on the air, right? And it goes straight to the point. So I'm going to read just a few for you. The government of Ghana acknowledges the joint statements, expressed concern for judicial independence and commitment to constitutional governance within the Commonwealth. It is, however, a matter of serious concern that the BCEW, which is the Bar Council of England and Wales and the Commonwealth Law Association, issued the joint statement without first acquainting themselves, even in very basic ways, with the relevant constitutional provisions and the material facts of the matter. And on that note, they outline the material facts of the matter up until May 15, 2025. So I'll move on to point 6 on this, because that's where a response to the BCEW and the CLA come. It says it must therefore be emphasized that there has been no constitutional breach or executive overreach in the consideration of the 3 petitions, and these petitions are those for the removal of the Chief Justice. Applications for interlocutory injunctions and judicial review brought before both the Supreme Court and the High Court by the suspended Chief Justice and her associates, in an effort to restrain or halt the inquiry committee proceedings, have been duly considered and dismissed by the courts as lacking in merit. We feel considerably reluctant to mention that the sound, including the very words of the BCEW and the CLA joint statement, vividly clones the dismissed grounds with which Her Ladyship Justice Torkornoo, and I mentioned this already, that some of the concerns raised by these 2 associations of the UK are very consistent with what the Chief Justice has been saying over time, very consistent with the Ghana Bar Association U-turn on this matter? And the Attorney General makes the same conclusions, right? Because he goes on to say that Justice Tokonu, the CJ, and her associates canvassed before the Supreme Court and the High Court. It is also important to mention that Justice Tokonu has presented similar arguments in her case before the ECOWAS court, which the government of Ghana is defending on behalf of its citizens. That the government of Ghana remains strongly committed to maintaining the independence of the judiciary, separation of powers, and the rule of law. I would end there because that is the crux of the matter. As the Attorney General fends off any suggestions otherwise to maintaining a transparent process being unfounded and risk distorting a constitutional process that is being conducted fairly, transparently, and in accordance with the law. So essentially, that's what the Attorney General has said in the last hour of the night. The concerns and demands by the BCEW and the CLA of the United Kingdom absolutely have no basis in the process against the Chief Justice at this time. I wanted to show you some of the reactions from social media. But what we are learning is that some of you are not happy because you see this as an interference, and I only have one question. Why? You think about that, or maybe the BCEW should think about that. We'll meet here same time Friday night for another edition of Ghana Tonight, but do make time 7 a.m. to watch Alfredo Kanse when he brings you key points tomorrow. Bye-bye.
But then there will be an act of parliament, like a Chief Justice, the former, I keep saying former, they suspended
Chief Justice.
Although the constitutional requirement no, so the constitution itself making provision for a committee to be set up and to conduct the investigation. And you know the required there will be extremely difficult compared to even 10 years.
Okay.
It will be extremely difficult to get the court to try to interfere with the proceedings in the court. It will be very difficult. Almost impossible.
I see. Because Neti and I make clarity is now Ankwanko Base will be feel say the suspend.
The law places limitations on your rights depending on the circumstance. And if someone under investigation can be the subject of an arrest, can be the subject of detention. So, and at that stage, you need to not go to executing your rights, like your right to a lawyer of your choice, etc.
Okay.
So, but be arrest, no, be only under investigation. All these rights do not put in because the law is not limiting the person's rights under any circumstance.
Okay.
And once we are under investigation, facing a committee, that is based on the constitutional requirement. Well, right here, to a larger extent, limited. And unless the investigation concludes, it will continues, to be limited. And if someone submit to the investigative process, it will be difficult to get the court to be on your side. So, I don't seem to understand why every now and then a person is found here near Palo, a quick report, near my airport. Now, Michael has doing some of this. And the most important thing is that the constitutional requirement, they said, the DA supposed to be in camera. That means behind the scenes. And he said, now the air course on outside. It will be difficult for the court to accept all that you are saying. It will be difficult.
I see. And then the defamation suit now what the Ghana call a person claim $10 million, similar.
And then I say the mother bring me home to say and not to and the local city because look in some of the bar and I say we are some two more that the author who to say investigation, you cooperate with the investigation as much as possible and show humility throughout the whole process and respect for the process and the procedures and the panel or whoever are in charge. Or if the forecast once a year, the new focus are immediately out.
Okay.
So,
our court of law, no?
Yes.
Okay.
Because you can go to the court and you have all the evidence and everything, but the court are also allowed to look at your demeanor. Demeanor, Sana many no a child the boy not a treasure and answer those type of things. And my brain. Enti who yes on my way and Nipana or Towa or baby decide you quit. Woman who say that be answer woman who say be at home now. Would you so make a diamond? That be. Enti and phone say be a once a year. So one far our Brazil and no respect the protest man. The one can put me to yourself in the foot. I see. And I think we don't match up. Because you can't me who's one of the and you could be said, even I give the day grant and the committee could conclude self reform. Even one or two of the passions, but this is passions grounds enough and not good enough. I didn't make us be a young penny in genuine India, young from Monaco. Now, young penny. That also a possible outcome. But so none of more in some to I think them. Then they say, or just what that. See, I didn't everything up on the side. If I'm best on that. And to me, the lawyer make me a too, but maybe Sanka, they all make the making of better maker. And you can sign him out. Now, on Brennan, you see the okay. Yeah, you say a big one more. 1 year, no year. The gives a number of that one. Now, if you call me, you are pocket, then I'm a 2 as a panel member, in fact, as a no criminal.
I see. Lawyer, and now Ben one come to Kusiyama, but only anti as a medal say. Because one man, many material for 70 years say. Said a bear, Obi, Quateba being cancer, and your time will be 10 will be an answer, my mini fuel crano. I judges all 100 tiny person, if you or name. Watch the position of the Constitution. One Obi under investigations at near Mranaka for Nino. One man minimum Tifunya and Tiasian and Naria. Yadasi Bibri. Okay. Lawyer Isaac Metalabi and no. And somebody can catch it and no. Obemia come to Kusiaman, but only anti as Sedana with the bed down on our fee. Majana Quinty, send your issues in the theatre. No, it's lawyer trim. It is a maybe a more argument you baby, but wait time that was say. Say, Obia, I under investigation, sir, or investigationer. I am not state, you know. Any the law court, a judges, you know. Say, when the state is after you, woman per se. Woman by interfere a juma muyemu. Because almost woman nim. And someone and our bonny and sebi wakodi anyhow a mushumin ekro. And when so ayo mino and enya. Eti atemwa for no maybe kisho say. Omo interfere. State prosecutors the juma di on person difa individuala. State to the face say why bibia esese ye ni mu hwehwemu ebio toko no de ne so was say no crowd here a constitutional mandate say o person we Supreme Court judge ana CJ mame kanisa na wakwa akokodi boni bia constitution no ewom ya twratum ekwan ya yemfa so it is a we a judge na ye fa constitution ni so na ye de ahwehwe bibi mu akwa kosi baabi na ye take decision of face o person sorry tie je so sorry tie de ya na wo no constitution na okra no ne fa baabi na ma wodi dwuma di courtroom ho no na sa woni constitution e kontokwa enti difference no it is sometimes so wunya asam aba face o man ni do o man ni mrawom etobia so so no DJ Kofi so pa Da benya asem no. Wenya me na me bonyo ma mahama body tinko. Omudo bako. Obi asunso ne ho. Sana issues ni nyina tie. Eti okọ no be argument bi ana amafo gichim na feso bi na time obi a. Pe ne lawyer acheche ma che na wie no. Yo kase ECOWAS no kra de. Onye prejudicial. But obetimi akase enkusiaga. Because ECOWAS phone to me Ghana is a sovereign nation. Eti emra yedi bu o man no obi go contrary. Na emra ni edia. O man fufuro bi na certain group of people being timi ko interfere because yen yedi ho. Aha, yedi ho. Sana issues no esifatie. Eti Ken of Oriata ene Gertrude Mami Saba Tokono. The suspended CJ ne hon komo ene akwakodia yere onsem so emanu. On that note, the law is the law is the law. Now you close that chapter no and so I don't know. So Parliament bakwaba. Okay. Oh no baba. But mama me tape mama me tape bako. Yeah, mama me tape bako. Yenko Azulud. Yes. Governs Kwame Agbuja. Governs Kwame Agbuja. Etienko Azulud. Nafi yeshe hawa ni masifatie.
Supervision of this road. The next thing I want to talk about is the asset load control reforms. If you have been watching the ministry, one of the biggest challenges we have is the asset load regime.
The lawyer, one of the lawyer, or part of the Commonwealth secret agenda, no, just a minute, no, Usheni Uruta or NPP. Yes, Usheni Uruta or NPP. Anna, a secretary of the Commonwealth, Shali Abuchi, or a former minister, a foreign minister, a work father benso, or a NPP. This one a Commonwealth, a secretary. Nti wohwe letter na ba abonte na te NPP cartel na na omugusu yesa adwuma na obebuja ze emra na sese emra no eye den wohwe emra no fa chief justice ni remover ni nyina no obehunu article 146 verse 6 no say of the constitution 1992. Article 146 of the 1992 Constitution of Ghana outlines the process for removing a Chief Justice. It specifies that if a petition for the Chief Justice removal is received, and first and foremost, the President received 3 petitions. Good, yeah, it was. So the President, in consultation with the Council of State, the President J petition or referring to the Council of what State into one acting on the petition on his powers into anti-emergency on refers to the Council of State. As it must appoint a committee to investigate. Into the President make a provision of appointing a committee to investigate. So this committee is to be composed of 2 Supreme Court justices, 1 as a chairman, and 3 other individuals who are not members of the Council of State, Parliament or lawyers. The Council of State plays a crucial role in determining if a prima facie case exists before the committee is even appointed. So after this committee, when this committee was set up, according to constitution, was it they must to determine whether there is a prima facie. Yes. So. And according to the committee response, they detect a prima facie case. Good, that was the presidential action. Was it if petition for the removal of Chief Justice is filed, the president must act. The president must act. So the president acts as the constitution is what mandating him to. Was it consultation with the Council of State? as I read, it okay in Kangwa was it the provision no esa makwan say the Chief Justice can be suspended according to President on air in any way into the constitution here. Omampanyi where this pepe state.